Decision podcasts by the New York Prosecutors Training Institute are made possible by VoicePods. Convert your text to voice at voicepods.com. Read this decision at NYPTI Law. www.nypti.org/law.
People v. Fidel Vega, decided May 7, 2019. Memorandum. The order of the Appellate Division should be affirmed. Defendant was charged with several crimes for beating the victim with a belt, including 2 counts of assault in the second degree. 1 count of assault in the second degree required the people to prove that with intent to cause physical injury to the victim, defendant caused such injury by means of a dangerous instrument, i.e., the belt with a metal buckle. See Penal Law 120.05. Defendant raised a justification defense at trial, on the basis of his proffered defense of a third person. See generally Penal Law 35.15. The trial court instructed the jury on the justified use of non-deadly physical force in connection with the lesser-included offense of assault in the third degree, which does not contain a dangerous instrument element. See Penal Law 120.00. At the people's request, the court also instructed the jury that if it found beyond a reasonable doubt that defendant used a dangerous instrument, then it should apply the legal rules pertaining to the justified use of deadly physical force. See generally Penal Law 35.15. The penal law defines deadly physical force as physical force which, under the circumstances in which it is used, is readily capable of causing death or other serious physical injury. Penal Law 10.00. A dangerous instrument is defined as any instrument, article, or substance, which, under the circumstances in which it is used, attempted to be used or threatened to be used, is readily capable of causing death or other serious physical injury. Defendant argues that the statutory definitions, while similar, are not identical and that a jury may convict a defendant of a crime containing a dangerous instrument element without necessarily concluding that the defendant used deadly physical force. Although it would be a rare case, particularly where, as here, the charge is assault in the second degree, we do not rule out the possibility that a defendant may be entitled to a jury instruction on the justified use of non-deadly or ordinary physical force, even though the defendant is charged with a crime containing a dangerous instrument element. See e.g. People v. Powell, L. v. Denied, People v. Griffith, People v. Ogodor. There is no per se rule regarding which justification instructions are appropriate based solely on the fact that the defendant has been charged with second-degree assault with a dangerous instrument. Instead, as in every case where the defendant requests a justification charge, trial courts must view the record in the light most favorable to the defendant and determine whether any reasonable view of the evidence would permit the factfinder to conclude that the defendant's conduct was justified, and, if so, which instructions are applicable. See People v. Petty, People v. McManus. Under the particular circumstances of this case, the jury instruction does not require reversal. See People v. Valentine. Viewing the record in the light most favorable to defendant, there is no reasonable view of the evidence that defendant merely attempted or threatened to use the belt in a manner readily capable of causing death or serious physical injury, Penal Law 10.00, but that he did not use it in that manner. Defendant's contentions regarding the legal sufficiency of the evidence pertaining to the 2 counts of burglary in the first degree are partially unpreserved and the remaining are without merit. Defendant preserved his contention regarding defense counsel's attempt to cross-examine the victim with respect to her alleged mental health history, but under the circumstances of this case, we conclude that the trial court did not abuse its discretion as a matter of law.
Decision podcasts by the New York Prosecutors Training Institute are made possible by VoicePods. Convert your text to voice at voicepods.com. Read this decision at NYPTI Law. www.nypti.org/law.